we'd like to thank everyone for coming to this informational session. It's being put on by the DREAM Act Faculty Alliance, DAFA. We have two lawyers with us today that are going to be speaking a little bit about what to expect, right, when these guidelines actually come out and what you can do now to prepare. So I'll introduce Sophia Goring-Kiard. This is Sophia here. And Sharon Phillips, who have generously given us their time to be able to come and discuss this with you.
So thank you again for inviting us, everyone. What we would like to do tonight, tell me if I'm speaking too fast for the translation, is to just give you information on what's available right now that the government has made publicly released to individuals on this deferred action policy for certain young people. As the USCIS, United States Citizenship and Immigration Services, has said, is that on policies like this, huge changes with immigration, we have to be vigilant and not just listen to what anybody is saying, right? You have to be educated and smart to understand what the rule is and whether it applies to you. On June 15th of this year, President Obama's administration announced that he would make available what's called deferred action to certain young people who met about 6 criteria that we're going to elaborate on. It's not a change in the law. It's an interpretation or a way that the government is going to enforce the law, right? So they've decided that for humanitarian purposes, they're going to allow young people who came to the U.S. before the age of 16 by no fault of their own. And what that means is we don't know yet, right? So if you came here, maybe a coyote snuck you over the border, we don't know if that situation is going to fit into this, but clearly if your parents or another relative brought you here under the age of 16 and you've been living here continuously, so either you made a lawful entry on a visitor's visa and that expired many, many years ago, or you crossed the border without any documentation, so you made an unlawful entry. The fact is you came, with your parents brought you through no fault of your own or some other relative, and you stayed in the U.S., you came before the age of 16. What the government is saying is you show you were continuously living here for 5 years before June 15th of 2012. So the earliest arrival you could have made under that is, you came June 15th of 2007, right? Up until June 15th of 2012, that's a 5-year period. Clearly, if you came before June 15th of 07 and you've been here all that time, that's fine as well. Now, again, we don't know a lot of what the nuances of these rules are going to be. So let's say you came here either June 15th, 07 or sometime before that, and you made a couple of brief absences. You left and you re-entered unlawfully. Well, currently, there are certain penalties that exist for repeat unlawful entries, and we don't know as yet how that's going to be construed under this new policy. All right, you must be in school, or you graduated from school, or you received your GED, or you served in the military. You also must not have had a felony conviction or no serious or significant misdemeanor or multiple misdemeanor offenses. So this is very tricky. Right. So any offense, clearly you need to seek counsel, whether it's a not-for-profit organization that's assisting individuals with these kinds of applications when it's time, or an immigration attorney, right? Seek competent counsel to analyze that particular provision, which is very, very critical. And as of June 15th of 2012, you can't be over the age of 30, right, to qualify. Within the 60 days after June 15th, the government said they will issue guidance. They will let us know for a lot of people who haven't even encountered immigration. You were never placed in deportation proceedings, right? You never had to go before a judge. You're just undocumented and living on the street. And I'm sure the application's going to ask about when you entered, right? How old were you on June 15, 2012? All the requirements we just went through will be on that application. Where do you live? Perhaps they'll ask about relatives that live with you, right? These are usually customary questions that they would ask on immigration forms. So I wouldn't be surprised if those are still the same things that we see on an application. Okay. But before we get into the specifics on what documents do I need, first realize this is not a status, right? It's not a path for you getting your green card or your citizenship.
Also to add to that, it's not something that you will have a right to. It's not creating a new right. It's not an amnesty.
Okay.
It's also not necessarily permanent.
The initial one is 2 years.
Right, so you'll get a work permit. So like we keep giving you bad news, right? Well, what's the good news? Why is it worth it, right? Because you'll get documentation to work, right? Finally, you'll have some government issued ID that says you can work, but it's for 2 years, and the government is saying it would be renewable. And then back to the bad news. Can I travel once I get this work permit? The answer is not quite clear, right? That's going to come out in the guidance hopefully by August 15th, August 16th. But let's say that the government says for certain people you might be able to also apply for travel authorization. That might also be something you may not want to pursue, and you will need to seek counsel. Because if you've been here unlawfully for many, many years, and then you travel, that departure activates other provisions of immigration law that might make you get stuck abroad. And with that work permit card, you would be able to apply for a social security number, right? Which is also something that's very critical for many people, especially students who want to go on to higher education and need to apply for financial aid and other enrollment issues. You know, usually not having a social security number just stops everything.
I think the important thing to remember is that the DREAM Act, the law that Congress has been talking about for 10 years, it's still in Congress. And that is still what we need to pass to get a permanent relief, a permanent status.
No, they have not set a limit. So they've only said it's renewable after the 2-year expiration. So, I mean, obviously if there's an administration change, right, if the Obama administration is no longer in power, this might be a very short-lived issue.
On the other hand, it may be politically very difficult to take this away once this has been given.
Yeah.
You know, we don't know the answer to that. That's why it's so important to make sure before you apply that you really are eligible and that you are not have some part of the eligibility that doesn't apply, because the risk is significant if you are not eligible and you submit all your information.
Okay, so individuals who are denied this discretionary benefit, depending on the reason for the denial, if it's because they have in fact committed a felony or a significant misdemeanor, right, then they could then be put into deportation proceedings, right? This is, again, discretionary. So the government is saying they're focusing their efforts on people who are low priority. They're going to give you this temporary reprieve because, you know, you're pretty much a good person. But if you come to their attention now and they now find out that you are switched to their high priority list, then they have all rights to initiate deportation proceedings against you.
So I was going to talk a little bit about what documents you can prepare now that you will probably need once we get the guidelines and we know what the passports, not just your current passport, but any previous passport. If you don't have your birth certificate, you can take this time to go to your embassy and apply for one and try to get one. To prove that you meet the education or military service requirement, you'll need your high school diploma, your GED, or proof that you're currently a student. If you've had any contact with law enforcement, any arrests, any tickets, anything, this is the time you can take to collect the documentation. You'll need an original disposition of each time that you were arrested or fined or cited or given any kind of penalty by the police or by a court. There will be, one thing we do know is that there will be biometrics and background checks. So if there's any record, they will find it, and if you haven't disclosed it, then you're creating a problem for yourself that wasn't there before. Another thing that would be useful to have is all your previous immigration records. If you've ever filed an application, if you've ever been in deportation proceedings, if you have any proof of the date you entered, anything that you ever received from immigration, you want to have that and bring that to whoever's assisting you with your application. We don't know yet all the definitions of what will be something that will bar you and what won't be. They have introduced this new term called significant misdemeanor. We do know that any 3 misdemeanors, even if they're not significant, will bar you. We know that if you have, so for example, if you drove when you were 12 without a license, and then you were, maybe had 2 traffic violations that were counted as misdemeanors, that could be a bar. And that's why it's important to get those records now, so that you can get legal advice before you file an application. And then there are three types of proof of being in the United States that you need. One, that you arrived before the age of 16. One, that you've been here continuously for 5 years. And you also need to prove that you were physically in the United States on June 15th of 2012. All those 3 things you need to prove. There are many ways of proving these things. If you entered legally, you may have a stamp in your passport. That's the best form of proof of the date you entered. You can also use, there's a whole list here, so I'm just going to, maybe we'll alternate.
And then I'll
Financial records, banking
read them through and then I'll read them.
Okay, financial records, medical records, school records, employment records, military records. Other things you can use are immigration court records, immigration applications, your I-94, your visa, driver's licenses, birth certificates of children born in the United States, marriage certificates, hospital records, school records. School records is going to be very important for many, many people. If you want your report cards from every year, that will show that you were here over a 5-year period. Utility bills, tax returns, rent receipts, other dated receipts, bank statements, personal checks with a stamp, employment records, credit card statements. All of these things, not just one, but year after year, so you can show the whole 5 years. So you need a continuous 5 years. You also need something that is earlier than 5 years ago to show you've been here 5 years. And you also need to prove you were here on June 15, 2012. Now, if you didn't go to the doctor on that day and get a receipt, you may not have something that shows you were here exactly on that day. Most likely they will accept documents that show you were here a few days before, a few days later, anything you have from the month of June. So this is good now. It's only July. Maybe you didn't throw everything away. Oh, it's August. Maybe you didn't throw everything away yet. Look for what you have that shows you were in the United States in June and hold on to it. Don't throw away your ATM receipts, your bus receipts, travel receipts, whatever you might have. Credit card statements, cell phone bills, whatever you have, you want to hold on to those things. But if you graduated from high school in June, that's great. If you attended a standardized test, that's all good. The last thing I wanted to talk about were the options for assistance that are going to be out there. The first and most important thing is, as you can understand, because if you file an application that is fraudulent, or an application for something you're not entitled to, or actually even just a badly done application, you're taking a very big risk. So the biggest message is stay away from notarios who are interested in making money and not in helping people. Immigration law is an area of law. You need to be licensed to practice immigration law. You should go to a licensed attorney or to someone who's been specifically authorized by immigration to assist. From a recognized, well-known nonprofit organization.
So I just wanted to, let you know one last thing that, if you walk out of here today and someone tells you, I've already gotten my grant of deferred action, right? Why are you waiting? I already got my status. It's possible that some people who are already in deportation proceedings have gone through this process because this is a policy that became effective on June 15th. Here we are August 1st. So when the policy became effective, that meant the government was authorized to look at files of people who are already in removal proceedings and determine, well, we're going to give this person or that person this grant of deferred action. And so they closed out the file, and these people could potentially get their work authorization. But for many, many other people who haven't encountered immigration, right, they're waiting to apply affirmatively. And that's what we're waiting on guidance on now. So those of you who haven't encountered immigration, haven't been in deportation proceedings, have never had a final order of removal, you are in wait mode.
Okay.
Lo que quieren hacer hoy es dar un poco de información de lo que es público ahora mismo del gobierno, de la acción deferida. Lo que tenemos es que estar pendiente con una política de inmigración como esta, que es algo nuevo, ¿no? De que tenemos que vigilar, estar vigilantes, ¿no? De solo tomar la información que es apropiada, que viene del gobierno y no de cualquier persona, ¿no? Tenemos que estar muy listos en buscar esa información. El 15 de junio, el presidente Obama anunció que iba a hacer esto disponible a ciertas personas jóvenes, esta acción diferida. Pero hay 6 distintas reglas para poder solicitar la aplicación a esta. So, no es un cambio de ley, sino es más bien cómo enforzar la ley que existe, ¿no? Y entonces es más bien por razones humanitarias para las personas quienes entraron a los Estados Unidos de los 16 y menor. Y es para personas que sin su propia falta están en los Estados Unidos. Entonces no sabemos, por ejemplo, si personas quienes vinieron a los Estados Unidos antes de tener los 16, si vinieron, por ejemplo, con coyote, si eso sí va a aplicar con esto, ¿no? Pero personas quienes vinieron con sus padres o diferentes relaciones, entonces ellos sí podrán usar esto. Puede ser por personas quienes o entraron a los Estados Unidos legalmente con visa, pero luego se venció esa visa, o también por personas quienes entraron como no legalmente, cruzaron la frontera con sus padres o con otra persona de la familia. Tienen que poder enseñar que han estado en los Estados Unidos por 5 años antes del...
5 años, continuous.
5 años continuamente, ¿no? Continuamente menos algunos cortos ausencias, ¿no? Pero que uno puede necesitar enseñar que ha estado en los Estados Unidos por 5 años continuamente, from June 15. Desde el 15 de junio, los 5 años anteriores. Significa que personas quienes entraron en el 2007, disculpe, el 15 de junio pueden solicitar. Personas quienes entraron en el 2007, disculpe, el 15 de junio pueden solicitar. Entonces, por ejemplo, personas quienes después del 2007 han tomado como breves ausencias de estar en los Estados Unidos, no sabemos cómo van a tratar eso en las personas quienes pueden al menos de los 5 años continuamente de estar en los Estados Unidos, uno también tiene que o estar en la escuela o haber graduado de la high school o recibido su GED. El equivalente. O ha servido en felonía. Uno no puede tener felonía. Un delito menor. Si alguien sí tiene un delito o algo semejante, entonces debería ir a consultar a alguna organización que le pueda ayudar o a un abogado o inmigración también para poder ver cómo se va a tratar ese delito bajo esta acción deferida. Uno tiene que en junio 15, el 15 de junio 2012 tiene que tener 30 o ser menor de 30. Mayormente para las personas quienes nunca han estado bajo orden de deportación o no se han envuelto en nada con la policía o en ninguna forma su estatus se había hecho conocido al gobierno. Entonces esperamos, el gobierno ha prometido que el 15 de agosto van a anunciar cuáles son los detalles, ¿no? Y luego también van a dar las aplicaciones para que las personas puedan... La cosa es que aún no sabemos qué va a estar en la aplicación. Pueden ser que le piden información sobre su domicilio, pueden ser que piden información sobre otras personas quienes viven contigo, cosas así, pero todavía no sabemos. Okay. Antes de que Sharon nos va a decir cómo puede uno, cuáles son los documentos que uno puede agregar ahora mismo, lo que necesitamos saber o reconocer es que esto no es un cambio de estatus. No es que una persona puede aplicar y luego desde ahí se va a como convertir indocumentado ha sido documentado, no es cambio de estatus. El estatus se mantiene. Tampoco es derecho, ¿no? Entonces, en caso por caso van a decidir inmigración propio si el sí o el no, si le van a dar esta acción. Y tampoco es permanente. Lo que le va a dar esta acción es que le va a dar una identificación con el gobierno y un permiso para poder trabajar. Esos permisos se dan por 2 años y luego después de esos 2 años uno puede pedir renovarlo de nuevo. Otra pregunta que quizás pueden preguntar es que si uno puede ya después de tener este permiso de 2 años para trabajar, si uno puede viajar con eso, ¿no? Y ahora mismo no sabemos. En esos 2 años que tiene el permiso, no sabemos. Quizás ciertas personas van a poder viajar, pero antes de irse en cualquier viaje deberían buscar consejo, ¿no? Porque si uno ha estado en los Estados Unidos por ya mucho tiempo y luego se sale del país, al regresar hay otras leyes que pueden decir que no puede entrar de nuevo por 3 o 10 años, dependiendo de cuánto tiempo ha estado en los Estados Unidos sin documento. Con ese permiso de trabajar también le va a dar un número de seguridad social, que para los estudiantes es algo muy bueno, ¿no? Porque con el seguro social uno puede aplicar y entrar en las universidades. Dice, esperamos que sí, van a dar esas becas o los estudiantes van a poder recibir esas becas, pero aún verdaderamente no sabemos, es lo que dice, nos dicen. Y luego también la cosa es que tenemos que reconocer que esto no es un cambio de estatus, entonces todos todavía tenemos que luchar para que se pueda pasar el DREAM Act, ¿no? Eso sí va a cambiar las reglas para los estudiantes quienes están yendo a la universidad. Por ahora mismo no sabemos si hay límites. Nos han dicho que sí se puede, para el permiso de trabajar, sí nos han dicho que sí se puede renovar, pero no sabemos cuántas veces, ¿no? La otra cosa es que esto también significa que también pueden quitar esto a cualquier momento, ¿no? Si se cambia la administración de Obama, quizás es algo que se puede quitar, pero también nos dice que también quizás sería muy difícil políticamente a quitar esto ya que se va a llegar. Es algo en donde inmigración decide en caso por caso el sí o el no. Uno también tiene que preguntar si uno pone la solicitud, la aplicación, entonces ¿qué es el riesgo si le dicen el no? Esto es porque es tan importante que uno vea o habla con alguien para poder ver si verdaderamente es elegible para esta acción, ¿no? Porque es algo de alto riesgo si uno pone la aplicación y luego le dicen no. Ahora mismo, esta acción es para las personas que el gobierno dice que son de prioridad baja. Entonces, si uno pone la aplicación y luego se hace como de prioridad alta por cometer un delito o una felonía, pues, entonces el gobierno tiene todo el derecho de proceder con todas las deportaciones.
Vamos a hablar ahora de qué documentos se pueden necesitar para aplicar a esta acción. Pasaportes y certificados de nacimiento, si tienen más de un pasaporte y el certificado de nacimiento. Si no tienen el certificado de nacimiento, es importante que vayan por el proceso de pedirlo por parte de la embajada o el consulado. Y toma tiempo, entonces es bueno aprovechar de este tiempo que todavía no sabemos nada de conseguir esos papeles. Se va a necesitar probar que uno tiene la diploma de high school o la diploma de equivalencia, una prueba de estar matriculado en una escuela, una universidad o del servicio militar. Entonces todos los documentos que comprueben eso. También es muy importante usar este tiempo para pedir documentos relacionados con cualquier contacto con la ley, sea un parte de tráfico, una violación de tráfico, de un arresto criminal, cualquier cargo que haya sido resuelto de cualquier forma. Hay que tener un papel original, la disposición original se llama Original Disposition, que da la prueba de cómo se resolvió. No, un gran error que se puede hacer es asumir que a lo mejor no se va a encontrar un delito pasado, sobre todo si fue resuelto o los cargos no fueron expedidos en la corte. Entonces no hay que asumir ni confiar con eso, hay que llevar documentación oficial acerca de todos los cargos previos. Todavía no se sabe cómo van a considerar los delitos, sobre todo los delitos menores. Se ha creado una nueva definición de lo que se llama delito menor significativo, que quiere decir que puede haber un delito menor, pero que cuente como algo significativo en la aplicación de la acción diferida. Entonces es muy importante tener todas las pruebas de todos los contactos con la ley. Es muy importante juntar todos los papeles relacionados con inmigración, con cualquier visa que haya tenido en el pasado, cualquier aplicación que se ha hecho por usted o por un miembro de la familia, cualquier carta que ha llegado de inmigración en el pasado, juntar todos esos papeles para poder conseguir consejo legal. Son tres componentes que hay que comprobar. Uno, que entró antes de la edad de 16 años. Dos, que ha estado viviendo continuamente los 5 años anteriores al 15 de junio de 2012. Y tres, que estuvo presente físicamente el 15 de junio de 2012. Son muchos documentos que se pueden usar para comprobar estas tres cosas. Records financieras, records médicas, records de la escuela, del empleo, de las Fuerzas Armadas, records de la Corte de Inmigración, aplicaciones a la inmigración, correspondencia con la inmigración, la tarjeta I-94. Lo mejor, dice, es una visa estampada si entró con visa, cuentas de CONED, cuentas de impuestos, cuentas de renta, recibos con fecha, información del banco, cheque personal con cualquier fecha, récords del empleo, las cuentas de tarjetas de crédito, fotos, cartas de un empleador, cartas de una iglesia, cartas de un sindicato o de otras organizaciones. Y dice, mientras más documentos, mejor, de todos los años que ha estado viviendo acá. Sobre todo los récords de la escuela para los que son estudiantes, las notas anuales demostrando que ha estado viviendo aquí. Cualquier información que compruebe que estuvo aquí el 15 de junio de 2012. Entonces han pasado apenas 6 semanas, entonces ojalá todavía tengan récords personales de esa fecha. Puede ser la cuenta del celular, puede ser un récord de ir al doctor, un récord de la escuela. Es muy importante entender que si uno pone una aplicación que es fraudulenta o una aplicación que tiene información equivocada o que está mal hecha, puede crear un problema en la aplicación y puede ser negada por esa razón. Entonces es muy importante conseguir consejos de calidad. Eviten los notarios, los que quieran cobrar para sus servicios y que no tienen el conocimiento necesario. Un abogado cualquiera no es necesariamente un abogado de inmigración. Entonces tiene que ser alguien que tenga el certificado para practicar la ley de inmigración o puede ser una organización sin fines de lucro que esté dando consejos de buena calidad.